Good evening, everyone. I am Gunika, your host for today's webinar on 29A Eligibility in Action. This session is designed to provide clarity on the procedural framework under Section 29A, and our joinees will be having a conversation. I'm delighted to introduce our distinguished speakers, Mr. Lalit Mathur, who is experienced in corporate law and co-founder of DCirrus, a leading technology company offering virtual data room, with our another distinguished speaker, Rahul Shankar, who is legal advisor with DCirrus, bringing depth knowledge and practical insights on corporate legal processes. We are honored to have both the speakers and let the session begin. I pass over to Mr. Lalit Mathur to start the session.
Thanks. Thank you, Gunika. Thanks for starting the session. And thanks, Rahul, for joining and taking out time to have this session today. So as Gunika mentioned, we are going to talk about the intricacies of Section 9A IBC. So we will do a sort of discussion and try to understand what Section 29A is, what are the judgments around, what are the challenges IPs and RPs are facing for 29A. So today we will explore the critical role of resolution professionals in ensuring comprehensive due diligence under Section 9A, with a special focus on landmark judgments on the said issue. Our discussion will also address why RPs must not curtail due diligence by selectively checking connected parties, rather having all the PRAs who have applied for the resolution plan and going for all the PRAs rather than selectively checking the parties, although all the PRAs are going under due diligence. But if there are thousands of parties involved, let the Section 9A applicability will be there for all the parties and not only on the selected parties. This will be emphasizing the need to cover all, as I mentioned, 3 levels of connected parties as specifically mandated by the IBC and Companies Act 2030. So without wasting any more time, we have Mr. Rahul, as Monica mentioned. He's our head legal and leading a team of almost 30 professionals working in the 29A due diligence. I think Rahul has a vast experience of handling more than 200, 250 due diligence till date. So welcome, Rahul. Welcome to the session. Thank you very much. So before we start this 29A discussion, so my first question to you is, can you give an overview of Section 29A and what's its importance and what's its...
Okay, Lalit. Lalitji, this code, Insolvency and Bankruptcy Code, come into effect in 2016, but in the original form, there is no provision with regard to how we can stop the defaulting promoters from buying the back from the corporate debtors. So in that situation, what happens that anyone can participate in a bidding process of the corporate debtors, right? So whether it is the original promoter, directors, or any person connected to that, who has some modified intentions also, they can participate in this CIRP proceedings. As a result, they can regain the control of the company again by bidding in the heavy discounts, and the other financial institutes have the haircuts only. So after this situation, what happens? The amendments come. There were 2 amendments. One was in 2017 and one was in 2018, by virtue of which this provision 29A was inserted, and few amendments in 29A which was inserted. More amendments were incorporated in that. So from the November 23, 2017, the 29A was incorporated in this act. And since then, we have to do due diligence as per the 29A. So first, I'll come to what it includes, right? It is to give us the specific eligibility criteria under clauses A to J, which includes undischarged insolvents, willful defaulters, persons with account classified as NPAs for 1 year, persons convicted with imprisonment or of 2 years, disqualified directors under Companies Act, person prohibited by SEBI from trading, and promoters who have who has the corporate linkage where there is a professional undervalued or fraudulent transaction has taken place, right? They have or the PRA who have executed a guarantee in favor of a creditor, which against whom insolvency resolution has taken place, or it is admitted under this code, or such guarantee has been invoked, I am saying, by the creditor, and the same remain unpaid. They are all are the eligible persons. Similarly, if the PRA has the similar disability, as I mentioned herein, they are also disqualified under any other law besides Indians laws. They will be debarred. It will be ineligible criteria. And the last but not the least criteria, if they have any connected parties which we are focusing in today's discussion, if there is any connected parties with regard to such PRA and they are disqualified, they are disqualified as per the sections from A to I. The PRA will also be disqualified. He will be treated as a disqualified and ineligible to take part in the resolution plan proceedings.
Okay. So what I understood, and then just to summarize that the whole idea of bringing in Section 29A in IBC is to prohibit the promoters to enter their own company through backdoor by having those haircuts and enjoying the debt which they have taken, and entering and just enjoying the debt and taking charge of the assets of the company which obviously they have built without paying the debt which they are enjoying. Perfect. In terms of so my next question would be that we are talking about you mentioned about section 29A and subsection, which we can discuss at a later stage. But what I have seen, when I see this, so there is a concept, there is a definition of connected parties as mentioned in that. Can you please elaborate more on that? So what is the actual, definition of connected party?
So the connected persons has been defined in section 29A J part. It says the connected parties are number one, promoters or the persons in the management control of the resolution applicant. Number two, person who will manage, control of the corporate CD during planned implementations in CIRP proceeding. Number three, holding companies, subsidiaries, associated, related parties as defined under Companies Act 2013. Beside this, as per 524, the related parties also, for example, spouse and all, they will also be considered as the related connected parties to the.
Okay. So which means that connected parties, as the term says and mentions, it has a very, very vast role, vast, and it's very, very exhaustive, so that the promoter should not take hide under his relatives or his or her relatives, and then enter the company through the back door. So I understand the nature behind these connected parties is very, very vast. Now moving to our next question, what are the layers, or I would say, what are the layers of connected parties as per Section A, for which we need to do due diligence to confirm the ineligibility criteria which you have mentioned earlier?
See, as per the definition, there are the three layers of ineligibility. Number one, person acting in concert. Okay, so person who are acting in concern means who has the common objectives, purpose. It can come through acquisition of shares, voting rights over a company by virtue of an agreement, formal, informal, directly or indirectly, getting the shares, voting rights, etc. Number two is the connected parties who will be the promoters and manager after control resolution applicant, who will become as a promoter, or who will take over the charge of the company when they acquire through CIRP proceedings. Number three, all the holding companies, subsidiary companies, associated companies, related parties of the company come under the definition of this. Third is related party. Related party here means any person to an individual, right? Or like their spouse, partners in the partnership firm, trustee in a trust, or in a private company. He's a director with and holds more than 2% share capital. So these are the persons. Okay, I will also like to share the three levels of the connected parties. Number one, which we have to check while confirming how many connected parties are there with the PRA during due diligence under Section 29A IBC. Number one, firstly, we have to check who are the promoters and the persons in management and control of the RA. Number two, we have to see who will assume control of the CD after plan approval. Are they free from the disqualifications or not? Number three, it encompasses the holding companies, subsidiaries, associated or related parties. It is as per the Section 270 of the Companies Act. It is not defined in the IBC, but we have to refer to Companies Law, Companies Act for this definition. And if they have the significant shareholding or common directorship, we have to cover and we have to check, do the due diligence of them also.
Okay.
And I also like to tell this three levels is very well defined in the judgment of one judgment Sivaram Yan Private Limited 2022, where it has been highlighted to need the check of the corporate affiliates. It is very important, and the RA was disqualified because one of the connected entity has been in under liquidation in that case. So I'll discuss more judgment with you in further. But this is one of the judgments which I like to pressurize on during this time.
Okay. Okay. So before we move forward, I also want to know what exactly you and your team, what's the process of finding, because I understand that there's a hell lot of data, a lot of data you people have to search and everywhere, wherever you find. So what is the process? I mean, how you do it? I mean, can you impress upon where do you search, like SEBI, CIBIL, defaulter? What exactly? Can you brief on the total process you apply while doing a 29A due diligence for?
Okay. So once we receive the information of the PRA, we ask the RP or the liquidator, as the case may be, to provide us the details. Specifically, we ask them to provide us the affidavit the PRA or the bidder provided them at that provide them, so that we can come to know who all are connected with them. This is necessary because it can be in the form of if it is a company, we ask for the balance sheets, audit sheets, etc., because they are needed for the purpose of getting the details of the connected parties, like who is the parental company, subsidiaries, associated companies, etc., etc., which will be which we can find only in the financial audited sheets and the details provided by the PRA in this regard. See, we have to see, as per the judgments as the precedents of the Supreme Court, we have to see only those persons who have the business transactions with the PRA. They have to be considered. So, if the related party, by the related party here, I am addressing to the relations like the spouse or to the parents and all who are directly involved with the PRA individuals in the business. So we require the details of such persons also, so that we can run the 2-level, 3-level checks on them also to see the eligibility criteria to confirm that. Once we get that detail, once we get details from them, we see how many connected parties are there. We shortlisted them. We then provide that list to the RP or the liquidator that this is the list and this much time it will take to conduct the due diligence. Because you can understand there. First, I will tell that this process is very time consuming and it needs efforts, because everything we also discuss what is the why it is time consuming. It is important at this point of moment to tell why it is time consuming, because verifying all three levels requiring checking multiple entities and individuals across jurisdictions requires exhaustive documentation and cross-referencing. We have to check, we have to see all there is multiple disqualification criteria, as I told you, A to J, which we have to check. And there is no the data source which is the reliable one data source. It is not it is not it is not available at single place. We have to search from different portals, from different sites. Like I see for CIBIL, we have to check from the CIBIL site. For SEBI, we have to check from the SEBI site. For disqualifications and all, we have to check from for disqualification under the legal cases and all. We have to check the sites like Supreme Court site, DRTs from NCLT, NCLATs, and all at district levels and all. So we have to see if the person is convicted or not, and for that we have to check. So there, all the data and all the data we are checking. It is from various portals, and the challenges which we have to face is that the RAs provide us the do not provide us the full information. For example, some RAs give us the SIN number, some give the DIN number, some give us the PAN number. So we have to check from the PAN that they have the DIN number or not. If they have the DIN number, they are the directors in other companies or not. Because in second and third levels, we have to check that also. It is a time-consuming process. There is no centralized database for the disqualification. We have to search various sites, as I told you before, and all the data depends. See that CIBIL is updated on once in the month. SEBI is updated every day. So we have to check it on the date we are providing the information to the RP. So we can provide the document after getting all the information checked from various portals. And if there are any red flags, we put it in the form of the queries and post it to the RP so that he can take the clarifications from the from the PRAs, what they have to set regarding those red flags. Once we get the information from these RAs, we prepare our report and give the signed reports. And on the basis of the reply we receive, we characterize them as the legible or legible, as the case may be.
Okay. So what I understand that even the process is time consuming and you have to search a lot of resources, which includes various government websites, SEBI websites, CIBIL website. And to be very frank with you, I don't know how robust those websites are, and what I'm sure there will be a lot of challenges in searching that.
It all depends on the speed. It depends on the speed of the sites also. Sometimes they are shut down. Some and it also take the time. We have the multiple research. So sometimes we are shoot out of the sites also.
Since it's a time-bound process, I mean, I can understand the challenges and the stress you and your team will have when there is a COC coming up and the RPs are, pushing you guys to give them the report in a record time and all those type of stuff. So this is quite interesting. But I want to impress upon here one thing, that even though you and your team, you find a lot of red flags, or you found that there is a PRA who is the potential PRA, and he's the one who has given the best offer to the CD, and the situations are totally good around that CIRP. And then, even though you found some red flags, you still give time and you still give an opportunity to the PRAs to come back, and obviously through RPs, to come back and explain that this you have find. For example, you find a case against some of the director in somewhere in Bihar. So you give that full opportunity to the PRA to explain what exactly it is, because I understand a simple mistake will not, or simple findings should not stall the whole process of a 1,000 crore CIRP. The idea is that somebody is willing to come and willing to come forward and taking these assets, and helping the company to rerun again for the sake of generating some employment and reviving the company. So this is quite interesting, that one, the data is captured at a voluminous level from the various sources. Second, it's analyzed by your team in the most efficient way. Third, all the red flags of those PRAs are informed to RPs and then further informed to the PRAs. The PRAs have the opportunity to explain to those replies. And then once you get that reply, then you analyze the data again. And if you have questions, you re-ask the questions. And then finally you generate a report which is duly signed and a conclusive report.
Right.
Because I've seen that there are some agencies who are giving the reports in more of a data form rather than giving a real conclusive report, which is just passing on the data to the RPs and their team, and then let RP will take a decision. I mean, this is not helping RP to take a decision. The RP is already having so much of pressure, so much of stress. On one side, he has to take care of the COC, on the side, he has to take care of the creditors who are just standing. And on the top of it, if the company is running, if the CD is on a running basis, he has to take care of the business also, the vendors also. I think it's quite a challenging time. The cherry on the cake is that everything has to be done in a specific time period. This is not like this is going on for years and years, and then everybody has their own sweet time to do whatever they want. So I can understand this is a challenging situation for RPs, a challenging situation for the PRAs who want to enter into the company, and it's a challenging agency for the whole ecosystem, like you and your team, to generate those reports in time and give to the RPs. Okay.
I also
Yes,
like to
please.
tell you one problem we used to face in this. See, if it is a common name, for example, Rahul. Rahul is very common name, right? There are
Yeah.
thousands of Rahul. So
Yeah.
many firms, as you said, many firms say this is critical. This is very critical. They search from. They take a data from a software stating this name is coming in this in willful defaulter. Rahul is coming into willful defaulter. They don't check whether the Rahul is the same Rahul which is concerned with the CD or with the CDRA or not. They simply say because Rahul is a defaulter list, so it is a critical stage. What we do, we'll ask the PRA through RP to tell us whether this case in this situation this Rahul is the same person or not. In this
Okay.
manner, we go from point to point, make all the due diligence properly, so that we can verify at the most we can do.
Perfect.
Yeah.
Perfect. And I'm sure you, once you ask these questions from the PRAs through RPs, you must have done
Hmm.
your own homework also, right?
Yeah, yeah. For
Homework. I
this,
mean, this is
see,
what is coming up. I'm a bit confused. I mean, the team is thinking this is ineligible, but let us
we
go
confirm
to
once
the
for
reconfirms the one,
yeah.
because the whole idea is that you don't want to stall the CIRP. If the process is fast, is smooth,
Right, right.
you want that resolution to happen. So this is quite a positive approach. I would say that's interesting. So just a question came to my mind, and I just want to ask you this question. So I'm sure when you send questions to PRAs through RP, how response? Because if you found something which is totally changed the whole
Right.
process, so do you get positive response, or you don't get any responses at all, or how you handle that?
See, in many cases, we get the response. Mostly the PRA who are sincere and who really wants to come into the picture and take the charge of this, they will reply. But if in case we don't get the reply, we cannot give the report because we are not sure, and we don't even want that RP comes to give the report or bring us some person whose sanity is doubtful. So if the person is really sincere, he will definitely reply to those queries.
Correct. Correct.
Yeah.
And that's the essence of Section 29A, right? Why the section exists is
Mm.
that's the essence. Right? So
Yeah.
the idea is to prevent the backdoor entry, right? And whether it's RP, you, your team, or whoever it is involved in the ecosystem, or the court, for example, NCLT or NCLAT or Supreme Court. So the whole idea is to make sure that Section 29A is compliant.
Backdoor entries.
No backdoor entries. Yeah. Okay. Now I see you get hell lot of data, thousands of connected parties, big resolution happening. So tell me one thing, why this comprehensive coverage of all connected parties critical? Because in practice we have seen that obviously there are various reasons for that. I don't blame anybody for that. So maybe there is a paucity of fund or whatever it is, or COC doesn't want to invest too much of money into these Section 29A process, and they want to have some sort of limited due diligence of certain parties. So whether that cherry picking is aligned with Section, why this comprehensive coverage is important?
I say there is only 3 points. Number one, to prevent backdoor entry, as I said, of the ineligible promoters or the related parties. Number two, there is no hidden disqualification. For example, NBA, SEBI bans or disqualification under MCA as a director in the related parties at the level 2 and 3. Number three, it should align to the IBC intent to exclude those who could harm the resolution process. So the comprehensive coverage is very critical. We have seen in the latest judgment of the Bhushan Steels that because there was not a comprehensive coverage, there was a problem, and even the Supreme Court go to the extent of reviewing the whole process. And it is still subjudiced. The matter is still subjudiced right now. So after that, 29A has really become very important. It was important, but it has come into the limelight after this judgment.
No, and I think it's the whole Bhushan Steel matter has actually, I would say it's a paradigm shift. I mean, nobody expected this to turn out like this. It's a full paradigm shift in the history of whatever small history IBC had. It's a full paradigm shift, and I have seen myself now the IPs are much more concerned about their actions. I mean, taking things very seriously in terms of how the process will run. What is the transparency? What are the processes? Whether Section 29A due diligence is done exhaustively or not. I think the bigger the matter is, the more serious it becomes. So moving forward, Rahulji, although you touch base this in the beginning, why this due diligence is so time consuming? Although you said that this is happening, but don't you use some tools or some AI or something and find out some results? And why it requires that specificity? And what are your challenges? I mean, in this word, I mean, I see everything is you and your team is manual. I know that you are using other software also to pull data out of it. There are a hell lot of softwares I know you guys are using apart from the public websites, and so you are just pulling the data out. So pulling the data is one process, but then when it comes to analyze how you do it, I mean, it's manually it's so difficult.
Besides the what we fetch from the softwares and all, we do the manual search also. We cannot totally depend on the AI things. We have to, especially in legal cases, we cannot do. They can take out the cases, but in the judgment we have to read which covers our point, which don't cover our point. There is one more point. In judgments we do not have the KYCs in the legal precedent. Everywhere there are no KYC. For example, if there is a judgment like Bhushan Steel versus Transco or GSW, names are there. But what are the SIN number? What are the DIN number? They are never mentioned. They are mentioned only in the SEBI cases. SEBI cases or NCLT, they might be there. But when we have to check for the 2 to 7 years imprisonment and that B and C clauses, we don't get all these details in the normal court cases at High Court, Supreme Court, and all. So we have to read all the judgments in which we get that it might be concerned with other PRA or RA related parties. That judgment could refer. So we have to read all the judgment manually. So we have the paralegals and myself read them, and then we conclude whether it affects our resolution. It comes under eligibility or not. Similarly, what happens? Why it is all the sites? For example, in DRT, I'll take you one by one. DRT, there are 1 to 3 courts, right? For example, in Delhi, there are 3 DRT forums. In Mumbai, there are 2 DRT forums. So we have to check various forums. Similarly, all the data are not available online. On the public domains, they are not available. We have to make the research. For example, in many cases, what happens, we get one order, more orders we are not having. We are struck, the sites are not opening. We get the name, but they are not opening. These are the difficulties which we have to face. Similarly, verifying, as I've told, we have to verify 3 levels, requiring multiple entries individual. It took the extensive time. It is very time consuming to open a site because they are in some sites, they are the captcha things and all. We have to check once, then close, then open. So it takes time. So that's why it's a very time consuming and it is a challenge for us. This is the some of the challenges which we have to face because there's no centralized database. There is we have to do the fraud checks for. And one more I would like to refer. In some cases, there are the foreign entities also. In those foreign entities, for example, the associated or subsidiary or the parent company is based outside India. They are not defined in the under definition of companies as per the Indian law, and their details are not there on the MCA sites or SEBI. So we cannot conduct the due diligence regarding them under 29A, as per the 29A, by searching on the public domains on these sites. So for this, we need the information from the PRA and RA only, or we have to go. We have to ask our associated foreign partners to do research for us because there is no 29A concept in foreign entities, foreign law.
Correct.
So there must be corresponding law to that. So what we do, we just see like are they willful defaulter? Any case is going on against the promoters of the foreign entities or the director of the foreign entities. They have been disqualified or like this manner. We can only search like this. But for that also, for the numbers of the connected parties they are having, we have totally rely on the documents supplied by the R, which they don't supply to us, and which is not also not available on the public domain.
And you mentioned that you have a lot of foreign associates as in your network. So which means that if you get a case, if you get a PRA's list and out of those 10 or 20 PRAs, some of them has foreign subsidiaries sitting in US,
Right.
France, Europe, or London, wherever in the world. So you mentioned that you have your associates who can help the RPs in getting getting these entities and these subsidiaries checked and find out whether there is any potential litigation going on in those entities or against their promoters or shareholders, whoever it is.
Yes.
That's quite a helpful information which you have provided. So now coming back to the question wherein what we call it a limited sort of due diligence because of various reasons. So do you think we can curtail the number of connected parties while conducting due diligence?
I will say it is a very dangerous practice. It legally flawed and risky. It is legally flawed and risky because it violates the statutory mandate. See, you can't be a choosy when there are sections A to their subclauses A to I. You have to check each and every clause. You cannot curtail. You cannot take into consideration as per your sweet will that I am conducting this at A. I am not doing the due diligence as per I. In few judgment, I will share. There is a precedent where RP has curtailed this. He has not considered all the and the disciplinary committee has taken an adverse action against him. They have suspended they have suspended his license for a year. Yes.
Oh, so you mean to
It violates the statutory mandate. It also risks the invalidating CIRP. GSP, this Bush and Steel, which is in limelight, it is perfect example of this. It also exposes RP to the liabilities, as I told about this case, in which that the disciplinary action has been taken against the RP in one of the matter in 2025 itself. And also, it also underestimates the creditor trust because it allows the eligible RAs to come into this process, which is totally against the statute for which this has come into the existence. So the intent of this statute is totally hampered if we try to curtail.
So your advice to the RPs is just don't curtail the numbers.
So,
If for the three levels, if there are connected parties, let the due diligence flow
from A to
it
Z.
from whatever A to
A
J,
to Z.
all the subsections are to be applied. Connected parties, whether it's subsidiary company, associated company, there should not be any cherry picking. If this is the list, and I believe you mentioned, I don't know whether you mentioned, so before you start the due diligence, you actually provide the full list of
Preliminary
connected
sheet,
parties to the
questions
preliminary
are
sheet, to the
used to provide. Yes.
questions and the preliminary sheet to the RP, which means that if as an RP I have 10 PRAs coming in and they all want to bid for a project for the assets. So before starting the actual due diligence, I will provide RP, you will provide RP a list of connected parties of all these 10 companies so that RP can and his team can read the connected parties, make up his mind, discuss with his team, and then come to you. Okay, these are the, so he has some sort of, I would say, some idea of all the connected parties much before in advance, before you guys, before you and your team starts the process of conducting the due diligence. Okay, that's, I think that will be very helpful. Yeah, please go ahead. You were asking
I
something.
also like to add. See, at the time of asking for the resolution plans, right? The RP asked them to fill in an affidavit, right?
Yes.
In the affidavit, it is under 29A IBC that they are not disqualified, as it has also been ruled out, observed in this Bhushan Steel. We have the RP. It is a duty of the RP to verify that the contents of the mandatory affidavit have been fulfilled or not. So if we check only A, the affidavit is in the form to A to I. They write, I am not willful defaulter. My party is not blah blah blah. This A
It's
to
like
I.
a very
Yeah.
standard
And it is a standard drawing
printed.
from A to I, right? That I am not disqualified under this, under this, under this. And if they are giving this affidavit, it is the RP and the liquidator duty to verify that the contents of the affidavit are true or not. And for that, you can't curtail. You have to see each and every. If he has given at the A that he is not disqualified, you have to check A. He has written it is not disqualified B, you have to check, and so on. So you have to check all. You cannot curtail saying that A is right, B is right, C is right. We curtail rest of them. We don't check the curtail. We do the first level, one level due diligence is enough. In my opinion, it is wrong. In the judgment of Bhushan Steel, there is the Supreme Court observed the ineligibility of the resolution applicant to submit the resolution plan goes to the root of the matter. It was incumbent on the part of the resolution professional to verify and certify that the contents of the mandatory affidavit filed by the resolution applicant is okay or not. It is the word-to-word quoted observation from the judgment of Bhushan Steel.
It seems the Supreme Court is very clear on the thought. They are very too much direct on all the RPs that just don't believe whatever these PRAs are filing the affidavits. Don't believe that affidavits. Go to the root of the problem. These are, I mean, Supreme Court in their mind is very clear about the 29A and very direct, and it's more like a direction to the RPs that go search, do your best. I mean, anything can happen, but at least demonstrate to the court that they have done their best, they have done the section 29A, they have found the connected parties, they have asked the questions. I mean, they have not left any stone unturned, and they have done their best to find out, and they have done their best of the best to get the 29A due diligence done before any CIRP.
Right.
Correct. Okay. So coming back to this Bhushan Steel, I think this Bhushan Steel is in the air and it will remain in the air for some time in the IBC ecosystem. So the Bhushan Steel judgment is still in limelight, right? It's still referred to the higher bench, and still there's a lot of things which will come out from there. What are other judgments which you think are important to consider and focus upon the issue of connected party and this section 9A due diligence report, and obviously, which will also help the RPs to understand that how important it is to get these 29A full due diligence. And you just mentioned that there is a matter wherein the court has ordered to debar the RP for 1 year because Section 29A due diligence was not done properly. Can you throw some light on that?
Yeah, I'll share few judgments. My colleague will share a slide regarding the same on the judicial precedent, which I think every RP liquidator should know. Specifically, I have marked the quoted the portions from the judgment itself, which clearly shows what the statute require from us, and in how we can what he expect us we should do while do the due diligence.
Okay, so are you sharing some slides?
Yeah, I'm sharing
Okay.
this slide.
Yeah, okay. Okay, no problem.
Okay, one second.
Yeah, it's okay. Take your time.
I think there is some problem in sharing. Only
Gunika, we can share. Gunika, you can send it to Gunika and Gunika can share. Is it in a Word format?
PowerPoint.
PowerPoint? Yeah,
So
you
you
can
can send the PowerPoint in the chat and I'll share it.
So you are not getting the share link, share button on the top. No problem. Gunika will share it. You can put that in this chat, meeting chat also. So by the time it pops up, in terms of so this I think I have also read somewhere about this disqualification, I mean suspension of RP because of this 29 MS. So I think this is quite interesting that each and every RP while doing this CIRP process, I think it's so much, it's too important for them to take this Section 29A very, very seriously. Because at the end of the day, if matter goes to the court and we know how the court works in India, I mean it's they are going to rip everything off and go deep into the matter just to find out what has happened in the past.
Just a minute, he's sharing.
Are there any? I mean, I'm a bit surprised. So, are there any website or any data which IBBI is coming out with, wherein which has collated all the data of all this? I mean, I can understand taking data from all over the place. It's quite difficult to collate it and then analyze it, and that's why it takes so much of time. So, you have sent it to Gunika or to me? Okay, you send it to me also.
Yeah, I have shared with you also.
Okay, let me see if I can share it. The first part would have been Gunika, but let me see if I can webinar PPT.
Page number 14.
Okay, so you want to go to page number 14?
Yeah.
Okay, important judicial precedents. Okay, you just let me know because I am running it. So you just let me know what to do.
So first I'll start with the Justice Chinnapai Reddy quoted words, which are holds very good even today also. The main gist of this judgment is that he says that statutes must be read holistically, aligning test with contest to achieve the legislative intent. So by you can see the last three lines. With these glasses, we must look at the act as a whole.
Sorry.
Getting-
No. I just I have to go back. Hold on. Let me bring it back. Sorry. Yeah.
Yeah, in the last three lines. With these glasses, we must look at the act as a whole and discover what each section, each clause, each phrase, and each word is meant and designed to say as to fit into the scheme of the entire act. No part of the statute and no word of the statute can be construed in isolation. Right? By virtue of this definition, it very much clear that we have to read each and every subclause. We have to take a holistic view of the act of the clauses. Each clause we cannot be choosy among. We take one clause and we do not do the another clause.
Correct.
Coming to next judgment. This is the Blue Frog Media Private Limited judgment passed by the Mumbai NCLT court. In this judgment, as I said, is said the NCLT stressed that the RP must conduct a thorough Section 29 due diligence, not relying solely on the RA affidavits. Right? It is written last four lines you can see. The resolution professional has from 27 at para 27 we write. the resolution professional has the responsibility to conduct Section 29A due diligence. A prospective resolution applicant submitting an affidavit stating that he is eligible under Section 29A to submit resolution plan will not suffice. Adequate due diligence on the prospective resolution applicants and its connected person need to be conducted effectively and with requisite timeline to identify eligibility, if any. The resolution professionals should seek clarification or additional information or documents from the prospective resolution applicants if needed for conducting the due diligence. Section 29A in its entirety not only restricts promoter but also the people related, connected with the promoters. It is obvious that the intention behind this inserting Section 29A is to restrict those persons from submitting a resolution plan whose could have an adverse effect on the entirety of the corporation or corporate insolvency resolution process. So I think this judgment clearly shows why we can't only rely upon the Section 29A affidavits supplied by the RA to the RPs.
Correct. I think everything has been said by the honorable court in a nutshell. It's so right. It's so very well written by the honorable NCLT Mumbai.
In the third judgment, NCS Sugars Limited judgment, it has been held that under Section 29AJ, it's related to RA, not to CD. It means that the connected party, what we are referring, they are not the connected party of the CD, but they are the connected parties of the RA. So what we have to check are the connected parties of the RA, not the CD. So thus from the explanation, going to this, we have carefully perused the Section 29. Come to the second para. Thus, from the explanation above, we find that the same speaks about the connected parties to the resolution applicant and not to the corporate debtor. The resolution applicant herein, being an as director of the corporate debtor, we are of the view that the contention of the respondent that the applicant is disqualified to submit resolution plan as CD is debarred by SEBI and the applicant is connected party to the CD is not maintainable. So in this case, the application was made that he is debarred because he is the connected party to the CD. The court says, no. J refers to the connected parties to the RA, not CD. And since he is not debarred, he is not disqualified. So in this, the promoter, the RA was one of the promoter, one of the ex-promoter, and the company being the MSME, he is exercising the relief given by the court to the MSME under 240.
The next judgment.
In this judgment, the court has observed and defined what is the RP role. The RP role is only of examining and confirming the Section 3 compliance without deciding eligibility. So the RP or us who are doing work on behalf or the due diligence on behalf on the RP, we are not the deciding factor. We have no power to decide. We have to just collect the data and give it to the COC, and it is their commercial wisdom and all to decide whether he is qualified or not. At para number 80 of this judgment, in the last 4 to 5 lines, it says the fact that the resolution professional is also to confirm that a resolution plan does not contravene any of the provisions of the law for the time being enforced, including Section 29A of 29A Code, only means that his prima facie opinion is to be given to the Committee of Creditors. So the RP has to give his opinion only to the Committee of Creditors that the law has or has not been contravened. Section 32E does not empower the resolution professional to decide whether the resolution plan does or does not contravene the provision of law. So why this judgment says, we just have to collect, verify, and hand over the red flag, if any, to the COC to decide. They have to take the stand. Okay. This next judgment, Bank of Baroda versus MBL Infrastructure Limited. In the Supreme Court says that this 29A does not only need for the RPs, it is need in the liquidation process also. So as per he has revalidated Section 35 1F or IBC. So it is also noted, Section 29A, it must be noted, it encompasses not only conduct in relation to the corporate director, but it in relation to other company as well. This is evident from Clause C, an account of corporate debtor under the management or control of such person of whom person is promoter, classified as NPA, and Clause E, G, F, H, and I, which have widened the net beyond the conduct in relation to the corporate debtor. So this judgment again say that we have to check all the subclauses. We cannot restrain ourselves only on 1, 2, A, B, C, or only one level. We have to check all the clauses.
All the clauses. Okay. Now go to next.
Okay.
Shri Krishna.
There's judgment. This Krishna Structures Private Limited versus Atif Gala. This is a very good judgment, because in many cases, as we well know, that the CIBIL is not updated. So in many of our cases, what happens? Payment RA has already done the payment, but the CIBIL are not updated properly, and it shows that on the date of on the date of the inspection, or on the date of checking the data, the NPA, they are shown as the willful defaulter, they are shown as the NPA holder and all on the site on the day we use the check. So in this judgment, it says that the NOC served as the irrefutable evidence attesting to the absence of any outstanding dues to be settled by virtue of this judgment. If the RA provides us the no due certificate for NPA status, and even if it is shown that on the site that he is a holder of the NPA site, we can safely say that he's eligible. He's not illegible. In such case, we can go by this no due certificate provided by the banker, that the NPA status is no more against that company.
Which no, so which means that even though the name is reflecting in the CIBIL, but the RA, if he produces the no due certificate, who will clear that RA is clear for the that RA is cleared.
So once we get we see that his name is reflected, we'll through our query we'll ask, can you provide us any documents to verify that you have already paid and there is no NPA status as on date. And if he provides us the no due certificate to us, then we can give him the clean sheet.
Okay. Are there any more judgments, Rahul?
Yeah, there are more judgments. This one is this is all on 248 MSME judgments which we are referring. We come to this judgment number this Estel Agro Ventures versus Vakati Bal Subramaniam Reddy. In this SRA being what happened in this case? In this case, the RA was ineligible as per sections. He was eligible as per section C, but ineligible as per section J. So court has said, because at one stance, for one section he's disqualified, and other he's qualified, the RA will be disqualified. This was the judgment.
Okay, so basically the idea is that the RA should be able to satisfy all the sections, all the criteria and subsection of 29A, and not only few of them, and others are disqualified. Perfect. I think that's quite. Before we close this session, my question to you is: what are your recommendations to all the insolvency professionals with regard to taking their decisions on? What do you recommend to all the IPs? What are your recommendations? You are doing it day in, day out. What's your recommendation?
My recommendation would be that the report which they are providing, on which they're giving, it should be a comprehensive report. It should cover all the three levels, and they should ask the PRA to provide all the documents to them with regard to the related parties and all, so that RK can assess the real connected parties, so that in order those situations can arise as it arises in the Bhushan Steels. And also in the Satpathy case, which I was referring, in which his license was suspended for a year because he has not conducted 29 due diligence properly. And the report which they are giving, RP is not liable to say that they are qualified or not. They can only give their viewpoints, and it is COC to decide whether it is their commercial wisdom to decide that RA is qualified or not?
I think this is a great session. I found is very insightful. I hope the RPs, the COCs, and other members will find it insightful too. And thanks, Gunika, for organizing all this for us. And I wish everybody a very nice, happy weekend. And we hope that Rahulji will come up with more ideas and more information. And if somebody has to reach you, how they can reach you?
Maybe call me anytime. No, but they can call me anytime. For any clarification, they can call.
Very good, very good. That's quite helpful. So thanks, Gunika. Over to you if you want to give a concluding remark. Otherwise, we are good.
Okay, thank you, Mr. Lalit Mathur and Mr. Rahul Shankar, for giving us invaluable information on this 29A eligibility and checklist and the impact of landmark judgments. And for all those who want to know about DCirrus, which is a virtual data room platform, can visit the website www.dcirrus.com and reach out to us for any time. Looking forward for more such sessions from both of you. Have a great day ahead.